I had to give up work 2 years ago as a teacher because of illness, long COVID. My wife is still teaching, still on full salary. Am I being stupid in saying we split everything 50-50?
Not a stupid question at all. There's a definite shift or reason to shift away from 50-50.
I had a total meltdown and had to phone the crisis team. I have spoken to my solicitor. We did my financial order. There is a percentage that I am allowed.
Absolutely.
And I nearly fell through the floor. I'm like, what?
Good. Whilst it may seem at times that, we just don't know where to turn, it does get better. Things are starting to happen now. Hi and welcome back to the Legal Queen live show. I am your host, Tracy Maloney, aka the Legal Queen on social media. I am a practicing family law solicitor and have been now for over 20 years. During that time, I've helped hundreds, if not thousands of people with their divorce questions and queries, with their child custody matters, with their financial troubles, i.e. who gets the house following the divorce. If you have a question similar to that, anything around family law, and you think that I could help, then please join me on my Discord channel, The Legal Queen. Come into the Legal Queen Lounge, pop your hand up, and I will bring you onto the stage and get you to ask your question. Now, on with the show. Andy, I've invited you up. There we go. What's your question, Andy?
Hello there.
Hello.
It's a bit of a financial question, really.
Yeah.
I separated from my wife in just before Christmas. I moved out. I'm now living back with my parents. I'm on limited budget because I had to give up work 2 years ago as a teacher because of illness, long COVID, things like that. Yeah. My wife is still teaching, still on full salary, etc. We do have a house together, which has got a mortgage. We do have a rental property together, which does have a mortgage. My basic question is, am I being stupid in saying we split everything 50-50, being as that I am unable to work now? Is my question.
Not a stupid question at all, Andy. Not a stupid question at all. So where we have a long marriage, and long really is anything sort of 9-10 years plus, the starting point
20,
is
over 20.
Okay, so definitely long. The starting point will always be 50-50, always. But that's only the starting point. We then look to the needs of the parties. And what that forces us to then analyse is, what's the party's earning capacity? And of course, you would now be seen as more vulnerable because that is compromised somewhat if you're not working. So there's a definite shift or reason to shift away from 50-50. What I can't do, obviously, on this public forum is give you specific advice, but
yes.
the starting point whenever I'm doing a consultation with a new client is to run through the factors that I know the court's going to be looking for. So length of marriage, age of parties, any children under 18, medical needs, earning capacity. What sort of equity do we have in the marriage at the moment, to get a bigger picture of that particular couple, and then we can focus in on, right, what reasons does my client have to move away from 50-50? Or indeed, I might be saying to them, look, you are the bigger earner, so because of that, your ex is going to get 60% or 65%. But always know that the court we're never going to get 100% and zero. I have a lot of people that get very scared and say, oh my God, I'm going to lose everything. Absolutely not. Any order that the court makes will be as fair as it possibly can. Parties walk away thinking, well, that wasn't very fair, but sometimes the court's hands are tied. It can only work with the assets that the parties have built up in the marriage. So starting point is 50-50, Andy, and from there it could go, in your favour. I'm going to assume, based on the limited information you've told me, it probably is the scales are going to dip in your favour. So we might be looking at 55-60% there.
Okay. My next question, because I've
Yeah.
looked and followed you on Facebook and things like that,
Yeah.
is, and I don't know, perhaps a lot of people want to know this, how do we get in contact with you to actually perhaps have a consultation?
Absolutely. So you guys can just email me. So tracy@maloneyfamilylaw.com. I answer all of the emails that I get. It's me that does them. The reason I say that is a lot of people in the office and go, well, I know it wasn't Tracy that answered the email. Absolutely it is. I make sure that it's me that answers all of them. If you follow me on Facebook, Andy, if you send me a message on Facebook, you'll get an automated response. Because of the volume of messages I get on Facebook, what I say to people is, I'm so sorry I can't answer all of these, but if your issue is pressing, email me. So, my email address is there. That's the best way to get hold of me. Alternatively, you can just ring the office and say, I want to get an appointment with Tracy, and the girls will book you in. Not a problem.
Lovely. Thank
All
you
right.
very much for your advice.
Pleasure. Take care. Bye,
Thank you.
Andy.
I've now had to apply for court because during mediation, just getting nowhere. And what I want to understand is, please, if you could tell me what the process is now, because what I was told is something around there's like a Section 7 that needs to be done, where a social worker comes. But I guess I'm just trying to understand, how long is it going to take? But then also, what's the likelihood that I'm going to get what I want? And what I want is an extra day per night, where my ex is trying to say you can only have him once.
Sure. So essentially, for those that maybe didn't hear all of that question, this is about a child arrangements application where dad has made an application to see his child for an extra night per week. The matter has gone before the court because the parents can't agree to that. And what the court routinely do when they're not sure or they don't know who to believe, mum or dad, they will instruct CAFCAS. CAFCAS are the social workers essentially, but they only work with families within the court system. So CAFCAS has been instructed. CAFCAS are going to ascertain now what is in the child's best interest. So the whole point of CAFCAS is that it will provide the court with an independent view. It won't be swayed by mum or dad. It will speak to both of you, and then it will decide actually what is in the child's best interests. Your next question to me was, how likely am I to succeed? You could take this either way. You could say that it is only one extra night. What's the point upsetting the current status quo? Because that's the starting point when a court's considering a child arrangements application. What's the status quo at the moment for that child? So it might be that an extra night the court thinks isn't worth it, or CAFCAS thinks isn't worth it. But of course, the flip side to that is, well, it's only one night. So what's the harm? Are we really going to upset the apple cart? Because of that, it's really difficult to answer your question. I would be pushing, because obviously you're asking me the question, if I was representing you, my argument to judge would be it really doesn't make any difference, but it would just level up the playing field, and it would mean that the child has more equal time with mum and dad as opposed to being more weighted towards mum, which has surely got to be in the best interest of the child. And also, parent psyche. It's really important that you feel as if you're getting the right amount of time with your children. So, but I can't be specific to your case, obviously. I mean, I don't know.
Of course, yeah. But just so you're aware as well, maybe for everyone listening as well, it's not actually me asking for one extra night. The current situation is, I will take him to school and pick him up for school two days, and he should be staying with me for those 2 days. But what's been happening recently is that on those days she takes him away, so she's actually reducing my time. And what her argument is, I should only be with him one night. So currently I'm actually meant to be with him 2 nights, but she keeps taking him away. So now I don't even get what I'm meant to get him.
That and in that instance, I would say that CAFCAS are going to be supportive of you. What you find is, unless we've got safeguarding issues or welfare concerns, we are minded to support the parent who isn't getting a lot of contact. Do you know what I mean? Typically, that will be dads. Typically dads will be ordered alternate weekends, which is no good to anybody really. So the court's always in favour, as long as it's safe to do so. and I have to say that for everyone that's watching, as long as it's safe to do so, the court's always sort of minded to increase contact so that we can level it up for the child, more so for the child. You know, so I mean, like I say, I can't guarantee, but I think that, you know, unless there's any welfare concerns that CAFCAS pick up on, I'm not sure what mum's going to say to justify that you can't have an extra night. Do you know what I mean? Usually they will rely on allegations, but I know you and I have spoken a few times before, and I really don't know what she's going to say to convince CAFCAS. The one tip I do always give, though, to parents who are about to speak to CAFCAS, and I've probably said this to you before, Speeds, is never run her down. I know you won't do that anyway, but to all the others listening, never ever run the other parent down. CAFCAS don't like that. They will make
As in talk bad about her?
Yes, yeah, because they will make the assumption that you will do that to the child or children. So always be diplomatic when you're talking to CAFCAS, because CAFCAS might sort of ask some leading questions. You know, why aren't you two getting on? What happened when you broke up? You know, what's the relationship been like since then? Really refrain from running the other parent down and try to keep it as diplomatic and as neutral as you can.
No problem. Thank you so much for your
Pleasure.
help. I'll keep you posted.
Yeah, please do. Okay, thanks, Speeds. Okay,
Bye.
bye-bye.
Good morning, firstly. How are you?
Hello,
Well?
I'm good, thank you. Thank you.
Good. I had a question because I'm at the end of my tether again. So I've exchanged financials. I've given her the money.
Yeah.
She's given me the house.
Mm-hmm.
We sent a D81 form up to the courts. They rejected it.
Mm-hmm.
And the judge said they wanted us to come. So then my solicitor went back to her solicitor
Yes.
to say, look, can we just mutually agree the D81 form so the parties don't need to go to court?
Yes.
Now, her solicitor is not responding whatsoever, and I don't want to go to court. What can I do legally?
The first thing I would want to explore to you is, why don't you want to go to court? Because it's not going to be scary at all. When we hand in a financial consent order to the judge along with a D81, a lot of times, the judge just wants to get clarification on a few things. You know, they very rarely say, no, I'm not making this order. They just want to get clarification. I think the other thing I wanted to say is that if her solicitor isn't responding, it might be that they haven't been paid, you know, or maybe they just think it's not worth charging our client to respond, to tell her to go to court. So that's where I want to start to ask you, why is it that you don't want to go to court?
Twofold. Firstly, I don't have the time. And secondly, I don't have the money to go to court because all the money that I did have, I paid her off. And I bought her out of the house.
I hear you. So in terms of time, it's probably worth finding the time, if I'm completely honest, because without going to court, you are not going to get your financial order. Without your financial order, you are always going to be at risk financially of her coming back to make a claim, okay? With regard to the cost of it, you don't need to instruct a solicitor. You can go yourself. It will literally be a chat with the judge. You know, it will be the judge asking you and her, okay, can I just clarify that you both know what you're signing here? It may be that he wants an explanation as to why you've decided to split the resources as you have, but you don't need to instruct a solicitor if you don't want to.
Okay, but there's no legal course that I have to make her, because everything has been agreed.
Yes.
It's just a mutual readjustment of the D81 form. So it's like a tick box exercise where her solicitors are just not responding. And the last
I was just going to say, your question there was, there's no way I can make her go. You can't make her go, no. But equally, if she doesn't go to court, then the court's not going to make this order. So if she doesn't go of her own free will, then you're going to have to make a court application. Remember, you're sending in the consent order and the D81 by agreement at the moment. But if she doesn't turn up, she being your ex or maybe her solicitor, that would indicate to me that it's no longer by agreement.
Okay. May I ask you one more follow-up question?
Sure. Yep.
So now, as you know, the child arrangements order has been set, done, and moved on. The son lives with me permanently, lives with order, but now she's turned around. She's turning around to say that she wants the child to live with her, but the child has been living with me for over a year.
Yeah.
He's going to be going to secondary school next door to my house.
Yes.
How do you think it would play out in the court of law if she went back?
Yeah, very, very, very difficult to overturn a child arrangements order, especially if we're asking the court to change where the children live. If this matter, which yours has, because you and I have spoken a few times before, so I'm aware, has already been dealt with the court. So it's already been through the process, already been through the system, and the judge has found it perfectly acceptable for the child to live with you. If mum now, and we have our final order, so if mum now wishes to make an application to change that, we call varying the order, judge is likely to think, but why? We've already been through this. We've already heard from both parties and the court's decided the child should live with dad. So mum's going to have an uphill battle from day one trying to change that. I would never say it's impossible, but it's one of the hardest applications to succeed on because the court's already decided on it. Does that make sense?
Yes, indeed.
Yeah.
Okay, fine. Great. Always a pleasure talking to you. Thank you.
You too. Thank you so much.
No
problem.
On listening in the background. Take care.
Okay.
Have a good day.
You too.
Bye.
Take care. Bye-bye.
Bye.
Hello. It's
Hello.
Candice.
Hello, Candice.
Hi. So I did speak to you the last time you was on live in regards to my partner's current situation and the application to school didn't. He refused the application to school, so the admissions said they'll stay at the current school.
Yes.
Mum's point blank refused to send them to school this week at all. The school have obviously been to see mum and stuff and done welfare checks and things.
Yes.
She's adamant she's not sending them, and she's adamant they're going to go to this other school. No applications being made to court to do a change or anything like that.
Yes.
So his concern is obviously they are currently out of education, not authorised, and the likeliness is school will report it to local authority for fining.
Yes.
So obviously he'll probably get a fine alongside mum, even though he's obviously not agreed with this time off school.
Yes.
Anything like that. So he's instructed a solicitor and all that's been done. And they've obviously said they've sent mum a letter to say go back, immediately send them back to school or be taking further action, things like that. But his main concerns are regarding the fine situation. So if he was to get fined, even though it's not on his agreement, obviously does he then have to pay it, or can he then request the payment to go through mum or get money back or anything like that?
Yeah, I would love to be able to answer that question, Candice. Sadly, I can't because that's very specific to school. That's not a family law question. My view would be that, if he was to tell the school, I did not give mum permission, I have not given her consent to do any of this, and I'm against it, actually. Ironically, he's against the children being kept away from school, that he shouldn't be fined. But I don't know how the school apply their fine system. I really don't.
Yeah, of course. It was more like if it was he'd put a claim in for anything like that, because the whole goal is they're going to go back to court to get sort of an emergency hearing, because obviously the children are missing out on education and it's not going anywhere.
And I think that's where I can help, because that was going to be my next piece of, or my next suggestion. He's obviously now seen a solicitor. They're going to get an emergency application in. His emergency application, I assume, is going to be specific issues so that actually the children are returned to school and, more importantly, stay at school, and maybe even a prohibited steps order to prevent mum from removing them from school again. So that's really important. But in terms of the fines, I couldn't help, sorry.
Well, the solicitor has also stated, because obviously she's refusing to send them to the school, that they're going to go down the prohibited steps and specific issue, but possibly apply for residency in the meantime, so that they do attend school.
Now applying for residence. Applying for residency is really difficult because we're changing the status quo. Whenever anybody makes a child arrangements application, the first thing judge is looking at, or the court's looking at, is what is the child used to at the moment? What is their routine currently? So in order for dad, I mean, you know, I don't think you'll have too much of an issue with the specific issues in the privileged steps order because, you know, if the children have always been at school, then again, it's the status quo. So court's not going to have an issue with that. But changing residence, he might struggle with. I don't know. His solicitor's better off advising there.
Yeah. That's fine.
All right. Hope that helps, Candice. No problem. Bye-bye.
Thank you. Thanks. Bye.
Hi there, Tracy. It's Steve
Hello.
again. How are you?
Hello, Steve. How are you?
I'm very well, thank you.
Good.
Just I keep thinking of random questions, not necessarily for myself, that might help other people.
Yeah, sure.
We were talking about lives with orders earlier on, and I just wondered, in my own case, we've got a lives with order with my ex-wife, with the children's mum, that's been in place for a number of years. Is there any advantage of going back to court and seeking a shared cared or joint lives with order?
So the advantages are more so for the children because as children get older, obviously their needs, their wishes, their feelings change. So I would never say dismiss it straight away. But of course, it's difficult to overturn that status quo. So I think step one would definitely be have a chat with your solicitor and just identify what you consider to be the benefits for the children. You know, maybe as a dad, if you've got sons, they're wanting to spend a little bit more time with you, which is perfectly understandable. Even daughters sometimes want to spend more time with their dad. As they get into teenagers, they tend to want to spend a lot more time with their friends. So that would be the first thing. But absolutely, I mean, moving from full residence to shared care is a lot easier than trying to go from full residence to switching residence. Absolutely. But I think the success in anybody wishing to make that application has to be centred around the fact that the children want to do it and how would they benefit from it.
That's really helpful. Yeah, I mean, at the moment, the children are sort of 13, 14.
Yeah.
And I guess part of my thinking is it worth the expense and the hassle? Are there any advantages to the non-primary care of going down that route?
Yeah, I think the expense, I always say, you don't have to have a solicitor. You can do it yourself. The one thing I would say, Steve, is that because your children are now 13 and 14, remember that children's orders will organically fall away at 16. If parents don't agree, we are going to be within the court system for at least 6, if not 12 months. So by the time we get there, your children are then going to be 14 and 15. So the emotional turmoil of doing it, the angst that it might create between the parents, that compared with the timeline, how long it takes to go to court, might put you off. Do you know what I mean? But don't worry too much about the expense because I wouldn't be advocating that you get legal reps involved. If your children are saying to you, actually, Dad, I want to spend more time with you, you would hope actually at that age that the other parent would listen to the children and go, absolutely, yeah, if you want to spend the weekend with Dad or a few more nights in the week, let's do it, rather than having to go to court.
That's really helpful. Thank you. I can see the hands up, so I will continue listening. I may have another question later.
Okay, lovely. All right. Thanks, Steve.
Tracy.
Thank you. I'm going to take a quick question off Facebook here. Tricia says, how do you get access to nephew if their mum and dad won't allow it if the nephew is only 7? Tisha, the reason that I wanted to answer this question is it's really important to understand that you have to have parental responsibility to make an application to Children's Court. Or if you don't have parental responsibility, you have to know the court would give it to you. And the reason I say that is that sometimes dads aren't on the birth certificate, but if they are biologically the child's father, then they will be given parental responsibility when they make the application. But for an auntie or an uncle, that's not automatic. So I would suggest that you're probably not going to be successful if you were to make an application to the court. In that instance, I would be suggesting mediation. You know, clearly the family's had a big fallout here. You're no longer allowed to see your nephew. Consider some family mediation. That would be where I would be advising my clients to start first. Okay. Vicky, thank you for waiting. How can I help?
Hiya, thank you. What it is, I've been in a civil partnership for 22 years.
Yes.
When we separated 2 years ago, we're putting the house up for sale. I've got 2 children. So I was just wondering what my rights would be with the property. Would it be a 50-50 split, or would I be entitled to more because obviously the children will be living with me, or is there no equal split? Is it obviously what the court decides and what we decide with the ex?
So I think the first thing I would say, Vicky, and it's such a good question, for those of you that can't hear the question on Facebook, what Vicky's saying to me is when a separation breaks down, how are the finances divided, essentially? You would always want to start by getting some advice, because each family is very different. You've mentioned to me their civil partnership. You've mentioned to me that there are children. So it may well be that this does move away from 50-50. The children are going to be living with you. I would want to know, and I'm not inviting you to answer on this public forum, Vicky, but if I was speaking to you off air, I would want to know things like how old the parties are, how old the children are, what both parties earn or have the ability to earn, what equity do we have available right now, what savings do we have, what is everybody's needs. And by getting the answer to those questions and more, I'm then able to say, okay, if this went before the court, then we're going to be looking at a 60-40 split or a 70-30 split, because I get a better understanding of what the parties need, and importantly what the children need. So you would want to start by getting the advice first, Vicky. Once you know what the court's going to consider fair and reasonable, then you're able to sit and speak to your ex and say, okay, I've had some advice. This is what my solicitor is suggesting, or how we split the finances. And of course, then you're able to measure if your ex is close to that, a million miles from that, or in complete agreement with you. And of course, that's important, because if they're a million miles from that saying absolutely not, it may be that we're looking at making a court application. But if we're fairly close to what the advice is that you've had, then potentially we could do some mediation to maybe just close that smaller gap. So whilst I can't answer your question, hopefully I've given you a bit of a direction as to where you need to start to find out the answers.
Yeah, that's brilliant. Thank you ever so much.
No problem.
Thank you.
Thanks, Vicky.
Can you hear me, Tracy?
I can, yes. How can I help, Z?
Oh, crikey me. Well, from our last chat, I had a total meltdown and had to phone the crisis team last weekend.
Yeah.
I have spoken to my solicitor.
Yes.
And we did my financial order.
Yes.
And he sent his financial order in.
Yes.
And spoke to her yesterday, and she's going to get the paperwork from what his side. She's going to give it me tomorrow, so I can see what's what. So I know what it is now on his pensions. Obviously, there's the property amount.
Yeah.
And obviously, the big thing is that he doesn't want to sell the home.
Yes.
Because he's put a lot into that. He doesn't want me to have his pension.
Yes.
Because that's what he's looked forward for all his life.
Yeah.
And obviously there's the inheritance that he got from his mom, as well. So then obviously his assets, he's put them down.
Yeah.
So I feel more positive.
That's good.
Tracy.
That's good, Z. You sound better. You do sound better to where you were from last week. I do remember the call, and I know that you emailed me, you know, from last week, and I went back to you. So you do sound better. Well, that's good. That's good, isn't it? Because whilst it may seem at times that, you know, we just don't know where to turn, it can be very overwhelming when we're going through divorce and finances. It does get better. It really does get better. And I say this to people all of the time. You know, it's really difficult to sometimes even put one foot in front of the other. But I'm so glad, Z, that you're feeling better this week, and that actually, since we last spoke, things are starting to happen now. You know, at least you have a bit more information. And I always think information and knowledge, it's almost gives you a feeling of empowerment then. You know, you can sort of, you know, tackle today a little bit better than maybe you tackled yesterday.
Yeah, I'll be able to see, once I've got it in front of me.
Yes.
I'll be able to see, because obviously when I spoke to my solicitor, she said that the X amount of money in the pensions.
Yes.
There is a percentage that I am allowed.
Absolutely.
And I nearly fell through the floor.
Yes. Yeah. Well, that.
And then when we discussed the property, and I said, well, he doesn't want to sell it. And the answer was tough.
Yeah. Good.
I'm like, what?
Good.
I says, but there is equity in there. She says, I know, because I know what's left on the mortgage.
Yeah.
She says, and I know what equity is in there.
Yeah.
So whether, and I'm horrible to gentlemen if you're listening, but she says, Zena, the amount of money he earns, that he's covered in everything. She says, you're not covered.
Yes.
Because of how vulnerable you are, and with everything that's happened, and everything that's happened to me, and where I am now to where I was 2 years ago.
Exactly.
And my mental health and everything. It's as well as my physical and disabilities.
Yeah.
So she says this is what we are looking at, because I was so scared, Tracy. I was so scared.
Yeah. Oh, and I get it, Z. I absolutely get it. You know, when we get so scared like that, fear, it can almost paralyze you from doing anything, you know, physically and mentally. We can't just move forward because we're so scared. So that's great. It's such great news that, excuse me, she was able to say to you, you're entitled to it. Of course you're entitled to it. So that's brilliant. Well, you know, good. Go on.
Sunday dinner, I was at my parents'.
Yeah.
And I was in the living room with my mum, and my mum just looked at me and she says, "You've got that look." I says, "Yeah, mum." I says, "I can't do this no more.
Yeah.
I just want my life. I just want a life. I just want my life back."
Yes.
And
good for you.
What my brother did on Sunday, he sent me some money and he said, "Go and get your passport renewed."
Yeah.
He says, because this has took its toll on you, my duck. He says, and you need a holiday.
Oh, lovely.
He says, and I don't care how much it costs. He says, I'm paying for it.
Oh, how sweet.
I says, Jay, you've done enough for me already.
Yeah.
He says, I don't care. He says, you're my sister. And he says, yeah.
Oh, that's so lovely, Z. What a lovely brother you have. That is amazing.
Yeah.
That's so good. Well, look, if you find the time between having a holiday and getting all your finances sorted, please come back and let us know how you're getting on, okay?
I will email you.
Lovely. All right. Thank you, Z. Thank you for sharing that.
All right, darling.
Okay. You take care. Bye-bye.
And you, okay. Bye.
I just want to share, and I'm sure Z won't mind me sharing this, but for those of you that are on the Facebook and couldn't hear that incredible story, Z came on last week and she was in a bit of a state, and she was sort of at the beginning, well, not the beginning really, but needed, you know, realised that we've got to sort the divorce and the finances out. She was completely terrified, feeling very intimidated, very lost in the wilderness of what is family law, and it can be very complex and overly complicated in my view. And of course, she's come back on to say that since then, she's seen a solicitor. She's a lot clearer about what she's entitled to, which has made her feel 100% better. And of course, her brother then said, right, all this has taken its toll, and he had agreed to pay for her to go on a holiday. So that is just a lovely, lovely story. Thank you so much.